Hello, future doctors. This is a continuation of our lectures. So, once again, I have downloaded another resolution from the Professional Regulatory Commission in their website, PRC website. So, this resolution is the adoption of the revised code of ethics of the medical profession. So let's begin. Whereas clause. Whereas the Republic Act number 2382, also known as the Medical Act of 1959, is the legal framework that provides for the supervision, control, and regulation of the practice of medicine in the Philippines. Okay. So in our previous lecture, we have discussed the Medical Act of 1959. So it is the organic law. It is the legal framework. It is the legal basis why there is a medical profession. Next is Article 3, Section 22, subparagraph 3 of RA number 2382 states that it is the duty of the Board of Medical Examiners, or the now it is the Board of Medicine, okay? The Professional Regulatory Board of Medicine, or PRBOM, to exercise the powers conferred upon it with the view of maintaining the ethical and professional standards of the medical profession. Okay? So the Board of Medicine is under the PRC, or the Professional Regulatory Commission. They are the body who is tasked to regulate the practice of medicine. Next is Section 9 of RA number 8981, or the PRC Modernization Act of 2000, provides for the following powers, functions, and responsibilities of the professional regulatory boards. First, to regulate the practice of the professions in accordance with the provisions of the respective professional regulatory laws. Second, to monitor the conditions affecting the practice of the profession or occupation, and whenever necessary, adopt measures as may be deemed proper for the enhancement of the profession or occupation, and or the maintenance of high professional, ethical, and technical standards, and to hear and investigate cases arising from violations of the respective laws, the rules and regulations, and their code of ethics, among others. So, the PRC Modernization Act is the legal basis whereby the Board of Medicine is given the power to regulate, to standardize the medical profession. Okay? So, next, as the accredited professional organization, APO, for the medical profession, the Philippine Medical Association, PMA, this is the mother organizations for medical doctors, commits to elevate the standards of medical education and practice in the Philippines. Article 7, Section 3 of the PMA Constitution and Bylaws provides for the proclamation of a code of ethics as promulgated by the PMA Commission on Ethics and approved by its Board of Governors for the guidance of all its members. Okay? So under this rule, it is PMA who has the power to promulgate, okay, code of ethics, and then introduce it to PRC in order for PRC to integrate it in their standardization. Next, the PRBOM issued resolution number 34, series of 2009, adopting the PMA Code of Ethics for the medical profession. Consultations were undertaken to review and revise the 2009 Code of Ethics in the light of the prevailing trends and developments in the medical practice. Okay? So the old Code of Ethics was updated. Okay? So the revised Code of Ethics for the medical profession was unanimously ratified during the 24th PMA General Assembly on May 16, 2019. So the Code of Ethics of the medical profession outlines the ethical rules and principles that shall govern the actions, decisions, and professional practice of physicians, with the end in view of ensuring the safety and interest of patients and the public in general. The code sets forth the professional responsibilities of physicians to patients, to the healthcare system, to the community, to the profession, to their colleagues in the medical profession, and to allied health professionals, and to the health product industry. So, by virtue of the power of PRC, be it therefore resolved that the revised Code of Ethics of the medical profession, which is annexed in this resolution, be adopted and promulgated for the observance of all physicians registered with the PRBOM, okay, the Board of Medicine, and the Professional Regulation Commission. So this revised Code of Ethics of the medical profession shall take effect 15 days from its publication in the official gazette or in any newspaper of general circulation. Okay? So it was adopted by PRC on September 19th, 2019. So this was adopted by PRC, the Code of Ethics of the Medical Profession. Okay? We have discussed this in our previous lectures. So this was jointly adopted by the Philippine Medical Association and the Professional Regulation Commission. Okay? So we have discussed this. Now, let's move on to another important topic. Okay? The Magna Carta of the rights of the patients. Okay? Once again, this PDF was downloaded in the website of the World Medical Association. Okay? Because this declaration is also the basis for our local Magna Carta of rights of the patient. So the World Medical Association, okay, adopted during the 34th World Medical Assembly in Lisbon, Portugal, okay, from September to October 1981, and amended by another assembly in Bali, Indonesia, on September 1995, and then editorially revised again in the World Medical Association Council session in Santiago, Chile on October 2005, and reaffirmed by the 200th World Medical Association Council session in Oslo, Norway, okay, on April 2015. So this is entitled the World Medical Association Declaration of Lisbon on the Rights of the Patients. Okay? So otherwise known as the Magna Carta of the Rights of the Patients. So let's begin. Preamble. This is an opening statement. The relationship between physicians, their patients, and broader society has undergone significant changes in the recent times. While physicians should always act according to his or her conscience and always in the best interest of the patient, equal effort must be made to guarantee patient autonomy and justice. Okay? So as you can see, the principles of ethics is embedded in this resolution. The following declaration represents some of the principal rights of the patient and that the medical profession endorses and promotes. Physicians and other persons or bodies involved in the provision of healthcare have a joint responsibility to recognize and uphold these rights. Whenever legislation, government action, or any other administration or institution denies patient patients these rights, physicians should pursue appropriate means to assure or to restore them. Okay? So what are the principles involved? Number one, right to medical care of good quality. Okay? So patients has the right to medical care of good quality. Every person is entitled without discrimination to appropriate medical care. Of course, if you are patients come from all walks of life, rich, poor, um, farmers, teachers, and so on and so forth. Okay? Everyone who is sick should be given appropriate medical care no matter the conditions. Okay? No matter your financial status. Every patient has the right to be cared for by a physician whom he or she knows to be free to make clinical and ethical judgments without any outside interference. Okay? It is the patient that has a choice to choose a physician. Next, the patient shall always be treated in accordance with her or his best interest. The treatment applied shall be in accordance with generally approved medical principles. Okay? So the physician must always be adept, okay, and always be knowledgeable with the new updates in medicine in order to give the proper medical interventions. Next, quality assurance should always be part of healthcare. Physicians, in particular, should accept responsibility for being guardians of the quality of medical service. Okay? Doctors are considered guardians of quality of medical service. Next, in circumstances where a choice must be made between potential patients for particular treatment that is in limited supply, all such patients are entitled to a fair selection procedure for that treatment. Okay? So no matter what status the patient has, old or he is young, he is poor, he is rich, okay? They are similarly situated. Hence, they are entitled to fair selection procedure for that treatment. That choice must be based on medical criteria and made without discrimination. Okay? Classic example for this is organ donation. Okay? So, in organ donation, first in line should be prioritized. Not because you are a politician or you are a very wealthy person. Okay? If you need the organ, okay, as soon as possible, based on the criteria, then you should be prioritized even if you are very poor or very old or so on and so forth. Next, the patient has the right to continuity of healthcare. The physician has an obligation to cooperate in the coordination of medically indicated care with other healthcare providers treating the patient. The physicians may not discontinue treatment of a patient as long as further treatment is medically indicated. Okay? As long as necessary. Okay? Physicians should continue the treatment. Okay? For example, if in our country, euthanasia is not allowed. Okay? What if the family members, because they have no money anymore, they ask the physician to perform euthanasia? And in the Philippines, euthanasia is illegal. So as a medical doctor, you must be firm. You will say no and continue the treatment. Okay? However, there are conditions which are in line with law. For example, the do not resuscitate order. Okay, it's not illegal. Or do not intubate order. Next, the physician may not discontinue treatment of a patient as long as further treatment is medically indicated without giving the patient reasonable assistance and sufficient opportunity to make alternative arrangement for care. Okay? So, in this scenario, it depends on the advanced directives of the patient. Next is the right to freedom of choice. So the patient has the right to choose freely and change his or her physicians and hospital or health service institution, regardless of whether they are based in the private or public sector. Okay, once again, the patient has the autonomy. The patient has the freedom to choose his doctor, to choose the hospital, to choose the service, okay, he or she wants. Next, the patient has the right to ask for opinion of another physician at any stage. Okay, second opinion, because of course doctors are only human. Okay, they can make mistakes, so that is why in the Magna Carta for the rights of patients has the autonomy to ask for another opinion. Okay, for his or her sickness. Number 3, right to self-determination. The patient has the right to self-determination to make free decisions regarding himself or herself. The physician will inform the patient of the consequences of his or her decision. So like what I've said, autonomy, okay, in this practice is very essential. However, the physician should assist the patient in making the decision or explaining the consequences of his or her decisions. Next, a mentally competent adult patient has the right to give or withhold consent to any diagnostic procedure or therapy. The patient has the right to the information necessary to make his or her decision. Okay? So it is basic in law and in the practice in the medical setting that if a physician performs invasive procedure, okay, like operations, the patient must sign an informed consent, okay, and the patient has the right not to sign it or not to undergo said therapies. However, the physician must explain to the patient the consequences of his or her decisions. The patient should understand clearly what is the purpose of any test or treatment, what the result would imply, and what would be the implications of withholding consent. Okay? Health teaching is very important in the practice of medicine. Okay? Because, for example, physicians failed to explain the procedure. Okay? And then because the physician was not able to explain it to the patient, the patient got scared and he did not sign the informed consent, and he did not push through with the um, operation, and then eventually the patient died. Okay, there are legal implications that might arise. Okay, due to this erroneous or incompetence. Okay, for example, when a patient was wrongly diagnosed, and then the physician performed a erroneous operation, and then the patient died, then a malpractice suit can ensue. Okay, so that is why it is very important for physicians to be um, knowledgeable with the protocols and the legal implications of his or her actions. Next, the patient has the right to refuse to participate in research or the teaching of medicine. Okay? So, once again, autonomy of the patient is a primordial consideration. Number 4, the unconscious patient. If the patient is unconscious or otherwise unable to express his or her will, informed consent must be obtained whenever possible from legally entitled representatives. Okay? So, if the patient is unable to give informed consent, the next of kin, his relatives, or the spouse, or any authorized representative can sign in his or her behalf. If a legally entitled representative is not available, but a medical intervention is urgently needed, consent of the patient may be presumed unless it is obvious and beyond any doubt on the basis of the patient's previous firm expression or conviction that he or she would refuse consent to the intervention in that situation. Okay? So, in case of emergency, and there are no relatives or spouse or any kin that could sign the informed consent, it is presumed that the patient, even unconscious, okay, wants to be attended. So that is why the doctor must act, okay, in accordance with the situation. Okay, so in case of emergency, the doctor must help the patient. Next, however, physicians should always try to save the life of a patient unconscious due to a suicide attempt. Okay? So, for example, if the patient committed suicide, even though with no consent, the physician, okay, it is the moral obligation of the physician to save the life of the patient. Next, the legally incompetent patient, or those patients with mental disorders, those patients with unsound mind, or incompetent, unable to give consent. So, A, if a patient is a minor or otherwise legally incompetent, the consent of a legally entitled representative is required in some jurisdictions. Nevertheless, the patient must be involved in the decision making to the fullest extent allowed by his or her capacity. Okay? So as a medical doctor, you must check the mental competency of the patient. Okay? Otherwise, you can ask the next of kin, the relative, or other authorized representative to sign in his or her behalf. Next, if the legally incompetent patient can make rational decisions, his or her decisions must be respected, and she has the right to forbid the disclosure of information to his or her legally entitled representative. Okay, of course, um, privacy of the patient is highly respected. Okay, um, privacy is very important in our jurisdiction, that in the Philippine setting we made a law okay, in order to protect privacy, in order to protect data. Okay, it is called the Data Privacy Law of 2012. We will I will discuss that in another lecture, okay? The data privacy, because it is really an very important law, especially today, where data is considered to be more powerful than oil. Next, if the patient's legally entitled representative or a person authorized by the patient forbids treatment which is in the opinion of the physician in the patient's best interest, the physician should challenge this decision in relevant legal or other institution. In case of emergency, the physician will act in the patient's best interest. So like what I've said, the physician must act according to the situation, okay? In case of emergency, it is presumed that the physician wants to be attended, okay? So the patient wants to be attended. So as a physician, as a medical doctor, you must because in law or in the constitution, in the constitution there is a hierarchy of rights, okay? And the top of this hierarchy is the right to life. So the right to life is the highest right, okay, in our jurisdiction. Procedure against the patient's will. Diagnostic procedures or treatment against the patient's will can be carried out only in exceptional cases, if specifically permitted by law and conforming to the principles of medical ethics. Okay? So once again, the physician must take into consideration the autonomy of the or freedom to choose. Okay? This right, God-given right of the patient. Next is right to information. The patient has the right to receive information about himself or herself recorded in any of his or her medical records and to be fully informed about his or her health status, including the medical facts about his or her condition. However, confidential information in the patient's records about a third party should not be given to the patient without the consent of that third party. Okay? The relationship of the patient and the doctor is fiduciary. It is on trust and confidence. Based on trust and confidence. So this relationship is inviolable. It cannot be violated. And anything that is learned through this relationship is considered private. You cannot divulge it. Even the court cannot compel you to do it because it is a privileged communication. Next is exceptionally, information may be withheld from patient when there is good reason to believe that this information would create a serious hazard to his or her life or health. Okay? Once again, physician should act based on the situation. Next, information should be given in a way appropriate to the patient's culture and in such a way that the patient can understand. The patient has the right not to be informed on his or her explicit request unless required for the protection of another person's life. Next, the patient has the right to choose who, if anyone, should be informed on his or her behalf. Okay? So this right to information focuses on the autonomy of the patient. Next is right to confidentiality. All identifiable information about the patient's health status, medical condition, diagnosis, prognosis, and treatment, and all other information of a personal kind must be kept confidential. Okay, like what I've said, anything that you have encountered or learned through this patient-doctor relationship is a privileged communication. Okay, it is confidential. The relationship of the doctor and the patient is fiduciary in nature. It is based on trust and confidence. So you should keep it a secret even if after death. Exceptionally, descendants may have a right of access to information that would inform them of their health risk. Confidential information can only be disclosed if the patient gives explicit consent or if expressly provided for in law. Information can be disclosed to other healthcare providers only on a strictly need-to-know basis unless the patient has given explicit consent. Okay? So the only way to divulge those information is through the consent of the patient. Okay? Even the courts, the trial court, the judge cannot compel the doctor to testify against the patient because this privileged communication is protected by law. However, there are also laws, okay, that would require you to divulge information. For example, right now, we are in a pandemic. So there are laws that requires you to report if a certain person is suspected of COVID-19. Okay, that is an example in this situation. Next, all identifiable patient data must be protected. Okay, in our jurisdiction, there is now a data privacy law that protects such information. The protection of the data must be appropriate to the manner of its storage. Human substances from which identifiable data can be derived must be likewise protected. Next, right to health education. Every person has the right to health education that will assist him or her in making informed choices about personal health and about the available health services. The education should include information about healthy lifestyles and about methods of prevention and early detection of illness. The personal responsibility of everybody for his or her own health should be stressed. Physicians have an obligation to participate actively in educational efforts. So, like I said, health promotion, okay? Health teaching is very important. So, as a physician, it is incumbent upon you to actively participate in any educational efforts. Next is the right to dignity. The patient's dignity and right to privacy shall be respected at all times in medical care and teaching, as shall his or her culture and values. Okay? Respect for human dignity. It is in the Code of Ethics. So it is also integrated here in the Magna Carta of Rights of the Patient. The patient is entitled to relief of his or her suffering according to the current state of knowledge. Next, the patient is entitled to humane terminal care and to be provided with all available assistance in making dying as dignified and comfortable as possible. Okay? It depends on the laws of the country. Because here in the Philippines, for example, euthanasia is not allowed. It is illegal. However, in other countries, euthanasia is acceptable practice. So sometimes the choice, the autonomy of the patient here in the Philippines is limited. Lastly, right to religious assistance. The patient has the right to receive or to decline spiritual and moral comfort, including the help of a minister of his or her chosen religion. Okay, once again, autonomy is given weight. Okay, freedom to choose, okay, is given weight. So that is the Magna Carta of the Rights of the Patient based on the World Medical Association. It is otherwise known as the Declaration of Lisbon on the rights of the patient. Okay? However, in the Philippines, there is a counterpart of the Magna Carta of the rights of the patient. However, it is still in pending in the Senate. Okay? This is still a Senate bill of the rights of the patient that entitled An Act Declaring the Rights and Obligations of the Patients and Establishing a Grievance Mechanism for Violations thereof and for other purposes. Okay? So this bill is still pending in Senate. However, we will discuss this because though this bill is pending, the provisions in this bill are already operational and they are cited by different medical institutions. Okay? So this bill is only a codification of those existing rules and regulation. So let's begin. Title and Declaration of Policies. So the title of this act shall be known as the Magna Carta of the Patient's Rights and Obligation. Okay? Once again, I will remind you that this is still not a law. This is still a bill, okay, pending in Senate. Declaration of Policy. It shall be the policy of the state to protect and promote the right to health of the people and instill health and consciousness among them. It shall likewise be the policy of the state for Congress to give the highest priority to the enactment of measures that protect and enhance the right of all people to human dignity. Towards this end, the state shall ensure, provide, and protect the rights of the patients to decent, humane, and quality health care. Now, Title 2, Definition of Terms. So, as used in this act, the following terms are defined as follows. Advance Directive. So, this is a document with a written instructions made by a person before he or she reaches the terminal phase of a terminal illness or a persistent vegetative state and incapable of making decisions about medical treatment when the question of administering the treatment arises. So this is like a will, okay? This is the voice of the patient once once he reach the level of incapacity, okay? He or she can no longer speak or can no longer impart the things that he or she wants. It includes, but is not limited to, a healthcare proxy or a living will. It is preferably a duly notarized document executed by a person of legal age and of sound mind upon consultation with a physician and a family member. So the patient execute this document before even, for example, now you want to execute an advance directive. So you ask a help to you go to a physician, okay, and then ask what are the medical procedure that needs to be addressed, okay, when, for example, that person becomes a vegetable, becomes a incapable of making decision, okay. So it directs the healthcare providers to refrain from providing extraordinary measures when the person executing such directive reaches the terminal phase of his terminal illness. Next term is emergency. An unforeseen combination of circumstances which is unanticipated and episodic, life-threatening, and there is this disability of function which calls for immediate medical intervention to preserve the life and limb of a person and or patient as may be determined by a responsible healthcare worker. Next, healthcare. Measures taken by a healthcare provider or that are taken in a healthcare institution in order to determine a patient's state of health or to restore or maintain it. Next term, healthcare institution. A site devoted primarily to the maintenance and operation of facilities for the prevention, diagnosis, treatment, and care of individuals suffering from illness, disease, injury, or deformity if in need of a medical and nursing care. Next, healthcare professional or practitioner. Any physician, dentist, nurse, pharmacist, or paramedical, and other supporting health personnel, including but not limited to medical and dental technicians and technologists, nursing aides, therapists, nutritionists, trained in healthcare and or duly registered and licensed to practice in the Philippines, as well as traditional and alternative healthcare practitioners. Next, health maintenance organization. Any entity licensed by the appropriate government regulatory agency which arranges for coverage designated health services needed by plan members for a fixed prepaid premium. Okay? For example, insurance companies. Next, human experimentation. The physician's departure from standard medical practice of treatment for the purpose of obtaining new knowledge or testing a scientific hypothesis on human subject. Another term, indigent patient. A patient who has no visible means of income or whose income is insufficient for the subsistence of his family. Okay? These are the poor patients that has no any financial capabilities. Next term, informed consent. The voluntary agreement of a person to undergo or be subjected to a procedure or other bodily interventions based on his understanding of the relevant consequences of receiving a particular treatment as clearly, truthfully, and reasonably explained by the healthcare provider in a manner and language understandable to the patient. Okay, like what I've explained before, informed consent is a document that a patient must sign before he undergoes an invasive procedure. Okay, so as physicians, as medical doctors, it is incumbent upon you to explain and to teach the patient on the pros and cons, okay, on the outcome or the possible risk involved of such procedure. Such permission must be in writing. Next is mass media. Embraces means of communication that reach and influence large numbers of people, including print media, especially newspapers, periodicals, and popular magazines, radio, television, and movies, and involved in the gathering, transmission, and distribution of news, information, messages, signals, and all forms of written, oral, and visual communications. Next, media practitioner. Any person who is engaged in the practice of mass media. Next, medically necessary. So it is a term, a service or procedure which is appropriate and consistent with the diagnosis and which, using accepted standards of medical practice, could not be omitted without adversely affecting the patient's condition. Next, patient, a person who avails himself or herself of health and medical care services or is otherwise the subject of such services. Next term, public health and safety. The state of well-being of the population in general, the protection of which may require the curtailment or suspension of certain rights of the patient. Okay? For example, the pandemic, okay, COVID-19. So it can curtail the public, I mean the government can curtail the rights of the patient or the public. Another term, terminal care, is an array of services offered by a team of doctors, nurses, therapists, social workers, clergy, and volunteers which provide active total care directed at maintaining or improving the comfort of a person suffering from terminal illnesses, including the management of pain and physical symptoms, and the provision of spiritual, psychological, and emotional support for the person and his family in an institution, a hospital, or at the patient's home. Care does not hasten nor postpone death. It affirms life and regards dying as a normal process. Care continues so that the remaining life can be lived to the fullest until a dignified and peaceful death comes in the terminal phase of the person's illness. Next is terminal illness. It's an illness or condition resulting in death within the foreseeable future. Okay? These are the critical illness. Next, terminal phase is the stage of terminal illness when there is no real prospect of recovery or remission of symptoms on either a permanent or temporary basis. Another term, traditional and alternative healthcare. The sum total of knowledge, skills, and practice on healthcare, other than those embodied in the biomedicine, used in the prevention, diagnosis, and elimination of physical or mental disorder. Okay? These are the alternative medicines. For example, by the use of organic materials. Next is traditional and alternative healthcare practitioners or provider. A person who practices other forms of non-allopathic, occasionally non-indigenous or imported healing methods such as reflexology, acupuncture, massage, acupressure, chiropractic, nutritional therapy, and other similar methods. Lastly, unwarranted public exposure. It is a situation where the patient is subjected to exposure, private or public, either by photography, publication, videotaping, discussion, TV broadcasting, or radio broadcasting, or by any other means that would otherwise tend to reveal his or her identity and circumstances under which he has or will be under medical or surgical treatment without his or her consent. Now, let's move on to Title 3, the Declaration of Rights. Okay? So, Section 4, the rights of patients. The following rights of the patient shall be respected by all those involved in his or her care. First, right to appropriate medical care and humane treatment. Every person has a right to health and medical care corresponding to his state of health, without any discrimination and within the limits of the resources, manpower, and competence available for health and medical care at the relevant time. Okay, so this provision has similarity with the World Medical Association's Magna Carta of the rights of the patients also, because our version is just a codification of the other existing rules and principles, okay, that is cited by different medical institutions, okay, all around the world. Like, for example, the World Medical Association. Next, the patient has the right to appropriate health and medical care of good quality. In the course of such care, his human dignity, convictions, integrity, individual needs, and culture shall be respected. If any person cannot immediately be given treatment that is medically necessary, he shall, depending on his state of health, either be directed to wait for care or be referred or sent for treatment elsewhere where the appropriate care can be provided. If the patient has to wait for care, he shall be informed of the reason for the delay. Patients in emergency shall be extended immediate medical care and treatment without any hospital, pledge, mortgage, or any form of advance payment for treatment. Okay? So, if the hospital or if the medical institution fails to provide care in case of emergency, then that hospital, it can be held liable, okay, for damages or any other forms of liability. And with respect to the doctor, the liability of the doctor is three-pronged, okay? The three-pronged liability of the doctor is first administrative, okay? His license can be suspended or revoked. Next is civil liability. The doctor can pay the patient in a form of damages. And lastly, the criminal liability. The doctor can be imprisoned. Second, right to informed consent. Okay, this is a very basic right and it is a mandatory right. The patient has a right to a clear, truthful, and substantial explanation in a manner and language understandable to the patient of all proposed procedures, whether diagnostic, preventive, curative, rehabilitative, or therapeutic, wherein the person who will perform the said procedure shall provide his name and credentials to the patient. Okay? The doctor must explain the procedure and also he must present himself that he is the expert. Okay? And then the possibilities of any risk of mortality or serious side effects, problems related to recuperation and probability of success and reasonable risk involved, provided that the patient will not be subjected to any procedure without his written informed consent. Okay, so an informed consent must be signed, so it is a document, except in the following cases. So this is the exceptions. In emergency cases, when the patient is at imminent risk of physical injury, decline, or death if treatment is withheld or postponed. In such cases, the physician can perform any diagnostic treatment procedure as good practice of medicine dictates without such consent. Okay? Like what I said before, it depends on the situation. So during emergency cases, the physician must help the patient. Next, when the health of the population is dependent on the adoption of a mass health program to control epidemic. Okay, classic example is how the government, okay, handle the COVID-19 crisis. Next, when the law makes it compulsory for everyone to submit to a procedure. Again, the example is the pandemic. Okay, now people are compelled to be tested, swab test or rapid test in order to know if that person has COVID-19. Next, when the patient is either a minor or legally incompetent, in which case a third party consent is required. E. When disclosure of material information to patient will jeopardize the success of treatment, in which case third-party disclosure and consent shall be in order. F. When the patient waives his right in writing, okay, those informations can be divulged, or informed consent is not necessary anymore. So informed consent shall be obtained from a patient concerned if he is of legal age and of sound mind. In case the patient is incapable of giving consent and a third-party consent is required, the following persons in the order of priority stated hereunder may give consent. Okay, so this is the order of priority. Number 1, the spouse. Next, in the absence of the spouse, the son or daughter of legal age. In the absence of these two, the parents. In the absence of these three, the brother or sister of legal age. And in the absence of these persons, the guardian. If a patient is a minor, consent shall be obtained from his parents or legal guardian. If next of kin, parents, or legal guardians refuse to give consent to a medical or surgical procedure necessary to save the life or limb of a minor or a patient incapable of giving consent, courts, okay, upon the petition of the physician or any person interested in the welfare of the patient in a summary proceeding may issue an order giving consent. Okay? So if those persons that are mentioned doesn't give their consent, and as a physician, as a doctor, you feel that the intervention or the treatment is necessary, then you can petition the court so that the court, okay, can give such order. Next, right to privacy and confidentiality. The privacy of the patient must be assured at all stages of his treatment. The patient has the right to be free from unwarranted public exposure, except in the following cases. A. When his mental or physical condition is in controversy and the appropriate court, in its discretion, orders him to submit to a physical or mental examination by a physician. B. When the public health and safety so demands. And C. When the patient waives his right. The patient has the right to demand that all information, communication, and records pertaining to his care be treated as confidential. Okay? Like what I said before, the relationship between the patient and the doctor is fiduciary in character. By fiduciary, it means it is based on trust and confidence. Hence, any communications, any informations obtained through this relationship is a privileged communication, and you are not allowed as a doctor to divulge it. Okay? Even the court cannot compel doctors to divulge any privileged communications. Any healthcare provider or practitioner involved in the treatment of a patient, and all those who have legitimate access to the patient's record, is not authorized to divulge any information to a third party who has no concern with the care and welfare of the patient without his consent, except A. When such disclosure will benefit the public health and safety. B. When it is the interest of justice and upon the order of a competent court. C. When the patient waives in writing the confidential nature of such information. D. When it is needed for continued medical treatment or advancement of medical science, subject to be de-identification of patient and shared medical confidentiality for those who have access to the information. Informing the spouse or the family to the first degree of the patient's medical conditions may be allowed, provided that the patient of legal age shall have the right to choose on whom to inform. Okay? So, autonomy again is given to the patient. In case the patient is not of legal age or is mentally incapacitated, such information shall be given to the parents, legal guardians, or his next of kin. Next is right to information. In the course of his or her treatment and hospital care, the patient or his legal guardian has a right to be informed of the result of the evaluation of the nature and extent of his or her disease, any other additional or further contemplated medical treatment, on surgical procedures or procedures, including any other additional medicines to be administered, and their genetic counterpart, including the possible complications and other pertinent facts, statistics, or studies regarding his or her illness, any change in the plan of care before the change is made, the person's participation in the plan of care, and the necessary changes before its implementation, the extent to which payment may be expected from PhilHealth or any other payer like the insurance companies, and any charges for which the patient may be liable. The disciplines of healthcare practitioners who will furnish the care and frequency of services that are proposed to be furnished. The patient or his legal guardian has the right to examine and be given an itemized bill of the hospital and medical services rendered in the facility or by his or her physician and other healthcare providers, regardless of the manner and source of payment. He is entitled to a thorough explanation of such bill. Okay? So, the hospital must itemize those bill. Okay? It must be detailed in order for the patient to know how much he needs to pay. And it is also the right to the patient to know what hidden charges the hospital has given. Next, the patient or his or her legal guardian has the right to be informed by the physician or his or her delegate of his or her continuing healthcare requirements following discharge, including instructions about home medications, diet, activity, and all other pertinent information to promote health and well-being. Okay? So these are just matters of reading. Do not worry because these PDFs can be downloaded in the websites that I will give to you. Okay? At the end of his or her confinement, the patient is entitled to a brief written summary of the course of his or her illness, which shall include at least the history, physical examination, diagnosis, medications, surgical procedure, ancillary and laboratory procedures, and the plan of further treatment, and which shall be provided by the attending physician. She is likewise entitled to the explanation of and to view the contents of the medical record of his or her confinement, but with the presence of his or her attending physician, or in the absence of the attending physician, the hospital's representative. Okay? So these are just matters of reading, guys. Notwithstanding that he or she may not be able to settle his accounts by reason of financial incapacity, she is entitled to reproduction at his or her expense, the pertinent part or parts of the medical record, the purpose or purposes of which he shall indicate in his or her written request for reproduction. The patient shall likewise be entitled to medical certificate free of charge with respect to his or her previous confinement. Okay? Take note that this is the Magna Carta of the rights of the patient. So any violations of these rights, okay, the hospital, the medical institution, the physicians, and other medical professionals can be held liable. The patient has likewise the right not to be informed at his or her explicit request. Next is the right to choose healthcare provider and facility. The patient is free to choose the healthcare provider to serve him as well as the facility, except when he is under the care of a service facility or when the public health and safety so demands, or when the patient expressly or impliedly waives this right. Okay? Example again is the pandemic. So right now, if you are COVID positive, you are housed in a place where you cannot go out. Okay, okay, where the medical practitioners has special skills in order to contain such virus. The patient has the right to discuss his condition with a consultant specialist at the patient's request and expense. He also has the right to seek for a second opinion and subsequent opinions, if appropriate, from another healthcare provider or practitioner. Okay? Once again, autonomy is given weight in this provision. Next is the right to self-determination. The patient has the right to avail himself or herself of any recommended diagnostic and treatment procedures. Any person of legal age and of sound mind may make an advance written directive for physicians to administer terminal care when she suffers from the terminal phase of a terminal illness, provided that A. He is informed of the medical consequences of her choice. B. He released those involved in his care from any obligations relative to the consequences of his decision. C. His decision will not prejudice the public and safety. Another right is the right to religious belief. The patient has the right to refuse medical treatment or procedures which may be contrary to his religious belief, subject to the limitation described in the preceding subsection, provided that such a right shall not be imposed by parents upon their children who have not reached the legal age in a life-threatening situation as determined by the attending physician or the medical director of the facility. Okay? This is very common because in a hospital setting, the religion, okay, of the patients are diversified, and some religious uh, organization, for example, they don't want another blood of the person to be injected to them. Okay, they don't believe in blood transfusion, so it must be respected, provided that proper procedure, okay, like signing of a waiver and other protocols is followed. Next is right to medical records. The patient is entitled to a summary of his medical history and condition. He has the right to view the contents of his medical records, except psychiatric notes and other incriminatory information obtained about third parties, with the attending physician explaining contents thereof. At his expense and upon discharge of the patient, he may obtain from the healthcare institution a reproduction of the same record, whether or not he has fully settled his financial obligation with the physician or institution concerned. Okay? So this right is inviolable, right to medical records, even though the patient has not paid the hospital or the doctor. The healthcare institution shall safeguard the confidentiality of the medical records, and to likewise ensure the integrity and authenticity of the medical records, and shall keep the same within a reasonable time as may be determined by the Department of Health. The healthcare institution shall issue a medical certificate to the patient upon request. Okay? You should issue upon demand. Otherwise, you can be administratively liable. Any other document that a patient may require for insurance claims shall also be made available to him within a reasonable period of time. Next is the right to live. Okay? Live. L-E-A-V, not L-I-V-E. Patient can leave the premises. The patient has the right to leave a hospital or any other healthcare institution regardless of his physical condition, provided that he or she is informed of the medical consequences of his or her decision. Next, he or she releases those involved in his or her care from any obligation relative to the consequences of his decision. Okay? For example, the patient must sign a waiver. Third, his or her decision will not prejudice public health and safety. No patient shall be detained against his or her will in any healthcare institution on the sole basis of his failure to fully settle his financial obligation. Okay? It's not allowed. However, she shall only be allowed to leave the hospital provided appropriate arrangement has been made to settle the unpaid bills. Provided further that the unpaid bills of the patient shall be considered as lost income by the hospital and healthcare provider or practitioner, and shall be deducted from the gross income as income loss for that particular year. Next is the right to refuse participation in medical research. The patient has the right to be advised if the healthcare provider plans to involve him in medical research, including but not limited to human experimentation, which may be performed only with the written informed consent of the patient. Okay? So, the Declaration of Helsinki. Okay, that is the prevailing declaration for human experimentation. Provided further that an institutional review board or ethical review board in accordance with the guidelines set in the Declaration of Helsinki be established for research involving human experimentation, provided finally that the Department of Health shall safeguard the continuing training and education of future health care provider practitioner to ensure the development of the healthcare delivery in the country. Okay? So later on, we will be discussing the Declaration of Helsinki. Next right is the right to correspondence and to receive visitors. The patient has the right to communicate with relatives and other persons and to receive visitors subject to reasonable limits prescribed by the rules and regulations of the healthcare institution. However, this right can be curtailed, especially right now where there is a pandemic. Okay? Next right is the right to express grievances. The patient has the right to express complaints and grievances about the care and services received without fear of discrimination or reprisal, and to know about the disposition of such complaints. The Secretary of Health, in consultation with healthcare providers, consumer groups, and other concerned agencies, shall establish a grievance system wherein patients may seek redress of their grievances. Such a system shall afford all parties concerned with the opportunity to settle amicably all grievances. Next is the right to be informed of his rights and obligations as a patient. Every person has the right to be informed of his rights and obligations as a patient. The Department of Health, in accordance with the healthcare providers, professional and civic groups, the media, health insurance corporations, people's organizations, local government organizations, shall launch and sustain a nationwide information and education campaign to make known to the people their rights as patients. Okay? So, the mass should help in the publication of these rights. As declared in this act, such rights and obligations of patient shall be posted in a bulletin board conspicuously placed in a healthcare institution. It shall be the duty of healthcare institutions to inform patients of their rights as well as the institution's rules and regulations that apply to the conduct of the patient while in the care of such institutions. Okay? These are just matters of reading, guys. Next is societal rights of patients. In addition to the individual rights of patients, the patients has likewise their societal rights. Following are the societal rights of the patient. The right to society. First is right to health. The patient has the right to regain and or acquire the highest attainable standard of health in a non-discriminatory, gender-sensitive, and equal manner, which health authorities and health practitioners must progressively contribute to realize. Next is the right to access to quality public health care. The patient has the right to functioning public health and healthcare facilities, goods and services, and programs needed and sufficient quantity. They shall likewise be provided with health facilities and services with adequate provision of essential drugs, regular screening programs, appropriate treatment of prevalent diseases, illnesses, injuries, and disabilities, including provision of public health insurance. Towards this end, the government shall, as far as practicable, approximate the international standard allocation for the health sector as set by the World Health Organization. Okay? So, once again, these are just matters of reading. Next is the right to healthy and safe workplace. The patient has the right to a healthy, natural workplace environment with adequate supply of safe and potable water and basic sanitation. Okay, this is important because some patients, okay, even though they are already well, they get sick due to the environment. It is called the nosocomial infection, okay, or community acquired infection. Okay, these are infections that are in the hospitals, okay, bacteria, viruses, germs in the healthcare environment. And potable water and basic sanitation, industrial hygiene, prevention and reduction of exposure to harmful substances, preventive measures for occupational accidents and diseases, and an environment that discourages abuse of alcohol, tobacco use, drug use, and other harmful substances. Next is the right to prevention and education program. The patient has the right to prevention and education programs on immunization, on the prevention, treatment, and control of diseases, for behavior-related concerns, for disaster relief and emergency situations during epidemics and similar health hazards. Lastly is the right to participate in policy decisions. The patient has the right to participate in policy decisions relating to patient's right to health at the community and national levels. Okay, this is what you call a consultative committee. Okay, where the government agencies consult the public. Okay, in order to gain inputs. Next, title number 4, the Declaration of Obligations. The obligations of patients. Patients shall at all times fulfill their obligations and responsibilities regarding medical care and their personal behavior. No rights. The patient shall ensure that he or she knows and understands what the patient's rights are and shall exercise those rights responsibly and reasonably. Next, obligation, provide accurate and complete information. Okay? Very important. Okay? Because right now we are in a pandemic. So if you lie to the doctor, it might, you know, have dangerous consequence. The patient shall provide to the best of his knowledge accurate and complete information about all matters pertaining to his or her health, including medications and past or present medical problems to his or her healthcare provider. Okay, and classic example: a patient went to China, Wuhan, China, before the pandemic. And when he returned to the Philippines, he has flu-like symptoms. And of course, the pandemic has not yet set in. So the doctor thought it was just ordinary um, cold or ordinary flu symptom. However, uh, when the days passed by, it was already too late because it was already a COVID-19 virus that the patient has because he got infected, and due to this history and due to the fact that he was not able to tell it to the physician, he lied to the physician that he went to China because the patient doesn't want to be quarantined. Then the doctor got infected and the doctor died, and then that doctor infected others. So that is why we are in a lockdown today because of that misinformation. Okay, so that is why it is very important to say, to provide accurate and complete information to the medical team. Next, obligation, report unexpected health changes. It shall be the duty of every patient to report unexpected changes to his or her condition or symptoms, including pain, to a member of the healthcare team. Next obligation, understand purpose and cost of treatment. The patient shall ensure that he or she understands the purpose and cost of any proposed treatment or procedure before deciding to accept it. He shall notify the healthcare provider or practitioner if he or she does not understand any information about his or her care or treatment. The patient shall insist upon explanations until adequately informed and consult with all relevant persons before reaching a decision. Okay? Just a matter of reading. Next obligation, accept consequences of own informed consent. So the patient shall accept all the consequences of the patient's own informed consent. If he/she refuses treatment or do not follow the instructions or advice of the healthcare provider or practitioner, he/she must accept the consequences and thus relieve the healthcare provider or practitioner of any liability. Next obligation, settle financial obligations. Okay? Because even though the hospital are for humanitarian purpose, they are still business. Okay? They need to give wages to their employees. That is why um, patients patients should settle their financial obligations. The patient shall ensure that financial obligations of his or her health care are fulfilled as promptly as possible. Otherwise, he or she shall make appropriate arrangement to settle unpaid bills in the hospital and or professional fees of the healthcare provider through post-dated checks or promissory notes or any similar medium. Next, relation to others. The patient shall so conduct himself or herself so as not to interfere with the well-being or rights of other patients or providers of healthcare. She shall act in a considerate and cooperative manner, respect the rights and property of others, and follow the policies and procedures of the healthcare establishment. Okay? Should work harmoniously with others. Next and last obligation, exhaust grievance mechanism. The patient shall first exhaust grievance mechanism provided in this bill before filing any administrative or legal action. So, title number 5, the grievance mechanism or the grievance machinery. First is mediation. Any written complaint arising from violation of any of the right of the patients under Section 4 of this bill shall first be submitted for mediation. Okay? In mediation, there is settlement between the parties. There shall be two types, namely hospital-based grievance mechanism and out-of-hospital-based grievance mechanism. The hospital-based grievance committee shall be composed of a grievance officer appointed and designated permanently by the hospital who shall act as a chairperson, and two physicians agreed upon by both parties as members. For out-of-hospital grievances mechanism, the committee shall be composed of the local health officer as chairperson and the barangay human rights action officer and representative of each from the Philippine Medical Association, the Council of Health Practitioner Association, and the Philippine Institute of Traditional and Alternative Healthcare as members. For this purpose, the Department of Health shall ensure the establishment of this grievance committee. Okay? So this compose the committee, the hospital-based and the non-hospital-based committees. The hearing procedure shall not be adversarial in nature. The patient and the healthcare provider or practitioner shall be given the opportunity to discuss the cause of the complaint and effort shall be made for its settlement. Okay? So the decision of this committee will be based on compromise agreement. No monetary compensation shall be involved during this stage, and neither shall a legal counsel be present at this stage. Okay, lawyer is not allowed in this stage of proceeding. The parties to the complaint shall be bound by the rules on confidentiality. The aggrieved party shall be given 30 days from occurrence of incident to file his or her written complaint to appropriate grievance mechanism. Upon the receipt of written complaint, the chairperson shall give due notice to the respondent. Upon receipt of the written complaint and due notice to the respondent, the grievance committee shall be given 30 days to resolve the said complaint. Okay? the committee has only 30 days to make a decision. Otherwise, the complainant shall have the option to proceed to the no-fault arbitration process or to file administrative and legal action under existing law. Okay? Remember the three-pronged liability of the physician, the administrative, and then the civil, and then the criminal liability. So those liability will not set in first if the patient will opt in this procedure. Section 8, no fault arbitration process. If and when the complaint is not resolved through mediation within the prescribed period, the complainant has the option to file a case for settlement at the no fault arbitration process. However, only complaints arising from the treatment-related physical injuries shall proceed to this arbitration process. The no-fault arbitration committee shall be a 5-man peer review team composed of physicians. The claimant and healthcare provider may choose one physician member each of the peer review team. The peer review team may come out with a decision based on documentary evidence, including depositions. However, hearings will be held to gather testimony. Within 30 days from receipt of the complaint, the committee shall make a decisions. All decisions shall be appealable to the Court of Appeals. Okay? So these are just matters of procedure and are matters of reading. Compensation shall be limited to actual monetary loss only. It will not cover for pain and suffering or other explicitly non-monetary losses. Okay? So these are pain and suffering are forms of damages. You can file this in civil courts. A healthcare provider compensation fund shall be established in all health facilities by health provider associations organization, or when not possible, through the Philippine Health Insurance Corporation. The funding shall come from assessment paid by the healthcare providers. For this purpose, the Philippine Health Insurance Corporation shall ensure the establishment of this fund. Section 9, prescriptive period. The time during which the case is submitted for mediation shall toll the running of the prescriptive period for the filing of a civil or criminal case under the revised penal code or any administrative case under existing law. And then Title 6, miscellaneous provision. Section 10, inclusion in school curriculum, licensure examination, and trainings. The provision of this act shall be considered in medical and medical-related school curriculum and licensure examinations, including trainings and seminars of traditional and alternative healthcare providers or practitioners. Rules and regulation. The Secretary of Health, in consultation with the Philippine Medical Association, the Philippine Hospital Association, the Philippine Institute of Traditional and Alternative Care, the Philippine Health Insurance Corporation, and concerned private agencies, non-governmental organization, and people's organization shall promulgate such rules and regulations as may be necessary for its implementation within 180 days from the effectivity of this act. And then repealing clause. All acts, executive orders, rules, and regulations or parts thereof that are inconsistent with the provisions of this act are hereby repealed or modified accordingly. And then this act shall take effect 15 days after the date of its publication in at least 2 major newspaper of general circulation. Okay? So like I've said, this is still a bill pending in Senate. So we will just wait for its approval, and then once it is approved, then it will be binding. Okay, in the Philippine jurisdiction. Okay? So, in this topic, that would be all, and then we will discuss further because this topic can be used in medical jurisprudence, okay, and medical ethics interchangeably because the principles involved in this topic is encompassing to both subjects. So if you have questions, do not hesitate to communicate with me. And thank you for listening. God bless us all.